Welcome, everybody. We are here for the first plenary event and the plenary panel of the ICONS Mundo conference. This first plenary panel will be dedicated to the topic of technology and the future of public law. We have a lineup of outstanding speakers, Catalina Botero from Universidad de los Andes, Colombia, Jamal Greene from Columbia Law School, and Sofia Ranchordas from the University of Groningen, Netherlands. Before we start, some housekeeping. We will have a simultaneous translation into Spanish for this panel. You just have to switch to the Spanish channel on the globe icon that should be visible at the bottom of the screen. The panel will be divided into three parts. We will dedicate the first part to a discussion and so giving the general remarks on the topic from the speakers. The second part, other 30 minutes, will be dedicated to a Q&A question between me and the speakers. And finally, for the last 25-30 minutes, we will open the floor for questions by members of the audience. So we can start from some general remarks on the topic that we are discussing. A question that I would raise to all the panelists is the following. I mean, given the importance that technology and digital revolution are acquiring and the effects that they produce on public law, my question is, what are the main challenges that public law will face in the next decades, according to you, as a result of this fast developing technology and digital revolution? So I will ask Catalina and then Jamal and then Sofia to respond this very little question.
Thank you, Lorenzo. Thank you very much. I'm really happy to be here today. So yes, this plenary is about the challenges public law meets in the fact of these technological developments. Unquestionably, here central issues are the regulation of artificial intelligence, self-driving cars, or the Internet of Things. But I would like to dwell in what I have been working for some years now: public law and its challenge to protect freedom of expression in Internet and simultaneously facing discourse abuse in the digital sphere. So allow me to speak about that issue. Considering that Internet is a global, open, interconnected, and centralized network, experts have pointed out that its governance should be designed by international multi-sectorial instances. However, at least in terms of content moderation, national judges are the ones being called by users to decide whether a particular content may or may not be left up in the digital realm. And courts are doing this without a sufficient support from public law. By the way, you may find some of the most remarkable judicial decisions on this matter at the webpage of Columbia Global Freedom of Expression Project at Columbia University. So I would like to present 4 insights coming from comparative constitutional law, and which can help us to build a normative theory capable to inspire the evolution of public law in this field. I know that in some legal cultures, these insights may sound somewhat exotic, but in my opinion, they can assist public law to cope adequately with freedom of expression in Internet. I will try to briefly mention, not justify, because 7 minutes are not enough, but at least mention each of these 4 insights in the remaining time. First, I think, like other scholars, that international human rights law should be the normative framework to guide any development in public law and any judicial decisions related to the scope of freedom of expression in internet. David Kay, former UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, offers excellent reasons for it in his 2018 report. International human rights law is an adequate foundation to develop a reliable doctrine based on common principles, metrics, and vocabulary to handle difficult questions concerning the scope of freedom of expression in internet in the most different contexts. Using such a doctrine will restrict the arbitrariness of internet platforms and state initiatives to censor content, but also, in Rapporteur's case words, it will provide inclusive environments that accommodate the varied needs and interests of internet users. It is true that this proposal has been target of several critiques, but also holds true that there seems to be no better alternative right now. In other words, to use a well-known formula, if to rule a global net, we need global rules, it seems today that international law of human rights is the worst alternative, except for all the others. But how to incorporate international law to domestic legal systems so national judges can use it as a normative reference? At this point, I would like to offer my second proposal. On this issue, the constitutionalism of some countries in the global south has much to offer. For instance, most Latin American countries, just as European countries like Portugal, in the post-war constitutionalism, we incorporated international human rights rules to our constitutional systems. In our countries, the case law of higher courts developed and still develops a rich, transformative, and consistent human rights doctrine, producing what some scholars like Armin von Bogdandy have called a common Latin American constitutional law. The third insight I would like to discuss tries to answer the criticism that if human rights law was designed to restrain state powers, then it is profoundly inadequate to transfer this system of rights to relationship between private actors. Once again, comparative constitutional law offers some exits. Some constitutional regimes recognize that private relationships do not always involve individuals capable to deploy the same level of autonomy. As such, in cases of clear inequality, when a relevant public interest is engaged, that is, when the case import goes beyond those directly involved, and a fundamental right may suffer a disproportionate impact, it is considered fitting the application of the horizontal effect of human rights. I am not talking here about the US doctrine of the state action. Neither do I refer to a theory of the indirect horizontal effect of human rights. This proposal is to use the doctrine of the direct effect of human rights between private actors to solve conflicts between platforms and its users. This doctrine does not ignore in any way the importance of protecting the right to autonomy in the relationship between private actors. However, it does recognize that the greater the power of a private actor is, the fewer that the alternatives for a user to express themselves are, the greater the public relevance of the suppressed speech is, and the lesser impact on other goods or interests protected by law are, then the fundamental right of freedom of expression will weigh more when resolving the tension between the relevant rights. Lastly, and related to what I just mentioned, to apply the principle of proportionality to cases like this, we must consider not only the two original opposing parties, namely the autonomy of business versus the user right to freely express himself. In the new digital era or sphere, there are other constitutional interests at play, like other users' rights or like the internet architecture itself. Thus, the devices of dialogical constitutionalism, and this is the last proposal, must be unavoidably incorporated to court proceedings. It is the user, the one who starts a dialogue, calling the courts to protect his or her rights. But decisions defining internet governance can only be correct when they are outcomes of a deliberative process in which multiple stakeholders of equal standing take part. So this is it, Mr. Lorenzo. Thank you very much.
Thank you, Catalina, and thank you for bringing to the fore already some key topics like freedom of expression and discussion about if should we need a global regulation or not. It's also interesting that this is something that a social media platform changed in its view, I mean, in the last years, that where they were like keen on not having any global regulation in basically asking for a global regulation. So that's very interesting. But I will now give the floor to Jamal for his first round of responses.
Thank you, Lorenzo, and thank you, Catalina, and thank you for inviting me to present on this panel. It's really an honor to address this audience. The question of what challenges public law will face in the next decade or so as a result of technology and the digital revolution is, as Catalina says, a very broad one, and one that one could take in a lot of different directions. The direction that I'm going to focus on arises, as with Catalina, out of my particular expertise and particular role, the expertise being as a scholar of US and comparative constitutional law, and the role as being one of the 4 co-chairs, along with Catalina, of the Oversight Board. Broadly speaking, I see one of the biggest difficulties as trying to adapt the structures, assumptions, and doctrines developed largely in the context of state coercion to the very different context of regulation of the expressive environment by private and public actors alike. So from my perspective, the truly challenging frame of mind is not precisely the translation from structures of state regulation to structures of private governance, right? The important dichotomy, or at least the most challenging dichotomy, to my mind, is not between public and private, right? It's easy to imagine public institutions entering the social media space, and in fact, they already have. Their presence in that space would not and does not meaningfully alleviate the problem of how to understand how the rule of law should structure the speech environment that these institutions create. There might be a way of kind of simplifying the problem that I'm trying to identify into a version of the age-old problem of positive versus negative rights. We have a sense, some sense, of the institutional, doctrinal, and remedial structures that are needed within domestic and international human rights law to vindicate the right not to have one's speech coercively curtailed. We have much less of a sense of what kinds of structures are needed to ensure simultaneously that everyone who wants to and is able to reach an audience is able to do so, right? To access a microphone, that everyone has the right to be heard and not just the right not to be muffled. But at the same time, ensure that the predictable chaos and harm that it causes to give everyone a microphone is mitigated and controlled, right? That's a challenge for a lot of different reasons. For one thing, it implicates the rights and obligations of platforms and not just the rights and obligations of individuals. So when we talk about hate speech, or we talk about harassment, or we talk about threats, or we talk about doxing or misinformation, platforms sometimes vindicate the right to be heard by allowing speech. And at other times, they vindicate the very same right by refusing to allow speech. In the context of what I'll just call oversimplifying negative rights, we generally prohibit censorship of speech, not because hate speech, for example, is good or especially worthy of being put out into the world. What we prohibit censorship because the benefits of censorship are not worth its cost in terms of personal autonomy, freedom from coercion, and other values that we cherish. We disallow censorship in the coercive context, notwithstanding certain foreseeable harms that can result from speech. But when it comes to platforms, the presence of the platform makes the host a participant in disseminating that content to the world, right? So hosts of platforms have a right, and in some instances a duty, to avoid that dissemination. That basic problem of multiple rights and duties that coexist and conflict with each other is complicated many times over by the speed and the scale of the internet, which can greatly exacerbate the harm of expressive utterances. People are going to inevitably disagree about how to strike the right balance here, and they're going to disagree intensely about it. In that context, I think it's fair to wonder whether there is any way of striking a balance between leaving harmful content out of public space and also permitting free expression, right? Given the complexity and scale of that problem and the amount of contestation around it. Whatever we think the answer to that question is, whether it's possible or not, I do think there is something that we as lawyers can do and ought to do, which is to insist on what we might call rule of law values. These are the values of equitable treatment of persons, of transparent and consistent application of laws and regulations, of reasoned decision-making and policy-making around content policies, for example, about the right to appeal one's treatment, about adjudication by neutral parties. We sometimes call these process values. And I think there's a lot to be said for focusing on those kinds of values. The question of whether platforms are making the right individual decisions, I think can sometimes even distract us from what are arguably more important questions of how they're making those decisions, subject to what processes. Those kinds of process values, I think, are likely to be a more effective point of entry for public law.
Thanks a lot, Jamal. It's very interesting how you brought to the fore the issue of the public and private relationship that is crucial, and how it's important to frame it in a different way, probably, in order to better understand this phenomenon. It's also, I mean, it's quite clear, and we will see that our discussion would be much focused on the role of the platform and the social media, and this is something that we will also have to see in the case that related to Facebook and Twitter versus Donald Trump. But I will now give the floor to Sofia.
Thank you very much, Lorenzo. Thank you so much to the organizers for the invitation and for organizing this wonderful event. I will share my screen and share with you a few slides that I have prepared. So, internet and technology in general is the gateway to information, to informational world, and it has the potential to equalize inequalities in different ways, to democratize speech, and to create economic opportunities. And in the last decades, the internet and platforms actually have allowed people to communicate information. And they're not only a vehicle, as it's often said, but they're also the message that they convey. However, even though the number of individuals connected to the internet has never been so big, what we have also noticed is that digital inequality is on the rise. In our digital world, being connected is simply not enough, because not all voices are equal, and actually not everyone can speak loud enough. In my preliminary remarks, I want to address 2 points that will hopefully help us think about the future of technology and public law. The first one is the issue of digital exclusion. and how technology deepens existing vulnerabilities and inequalities, and the need to actually go beyond just the study of unequal treatment. And the second one is focus on platforms, of course, and how the platforms actually also are a sign of the rapid disappearance of public power, but also of the fact that there are checks and balances that may actually get lost, especially when platforms do not step up and actually make sure that they also safeguard rule of law, as was just mentioned by Jamal. Starting with digital exclusion. Even though half of the world's population is now online, barely anyone can call themselves digital citizens in many of the countries that are in the global south. Digital citizens are individuals that have knowledge and skills to actually fully interact with technology in a critical manner. Digital citizens are not only just internet users, they are individuals that have not only social capital, but also digital capital. And that means that they actually can fully interact with technology and also grasp all the economic opportunities that they actually offer. However, this source of inequality that we see here by the lack of digital capital is affecting mostly the groups that we already can expect to be affected. So women, migrants, senior citizens. Having the ability to use Facebook or Instagram, which are incredibly user-friendly platforms, does not mean that someone has the digital skills to, for example, have access to healthcare, as we have seen during the pandemic. Or the fact that a country has 5G infrastructure does not mean that all its citizens, including in the north, in the Western countries, can afford access to the internet. We have seen this actually during the pandemic as well. Nevertheless, the legal literature has mostly focused on other aspects, such as algorithmic biases, discrimination, and transparency. Access and digital capital have been forgotten by many of our colleagues. And all of these issues that have been studied are very relevant, but they do not suffice to fully acknowledge the impact of technology on public law. So what I propose that we look beyond unequal treatment, because millions of citizens in Western and non-Western worlds are right now perhaps connected, but they are still excluded because they're not able to or willing to engage critically with technology. And this digital exclusion has been mainly analyzed by non-lawyers, by communication scholars who have acknowledged this fact, but who are not really able to provide solutions. However, when everything or most everything plays out in the digital world, not having skills, being digital excluded, not being able to be a digital citizen, might actually mean that citizens cannot exercise much more than just being treated equally. There are other fundamental rights that might get lost. So, for example, the right to due process, equality of arms, but also privacy. And this is important because we see that technology is being used by governments increasingly more, especially in Western countries. So not knowing how to actually engage quickly with technology is also not being fully protected. And now moving to the second point, for vulnerable populations, big tech technology is a double-edged sword. As I mentioned, all these platforms are very easy to use, and they are used even by vulnerable populations. However, technology has actually these two sides here. On the one hand, technology maximizes the provision of services, including public services. It democratizes information. It ensures that people can keep up with information just going on in general. However, technology also maximizes the efficiency of the combat against fraud. It allows governments to actually scrape information from social media to obtain information on their citizens. And here we start seeing the sharp side of technology. For vulnerable citizens who require additional assistance, digitalization and automation relying on big technology can actually increase so-called government anxiety. The feeling that actually anything you can use, that you can actually upload online can be used, it will be used against you. And unfortunately, as many scandals around the world have shown, for example, in the Netherlands with the childcare benefit scandal, very often this anxiety is actually justified. We know also as well that big tech has also converted cities, for example, in spaces where citizens are treated as providers of data, where they are basically treated as objects, and where basically big tech promotes narratives that are mostly focused on tech-savvy citizens, on average citizens, and also exclude citizens that do not fit within traditional gender categories or stereotypes. We know very little about the legal position of the citizens that feel excluded and how big tech can help or actually deteriorate their position. So I think it is important that when we talk about the future of technology and public law, we talk about two key aspects. First, we talk about access to technology and how technology deepens existing vulnerabilities, because we see that digital inequality denies vulnerable citizens their rights twice. First, ethnicity and socioeconomic status might be conducive to negative rankings or scores, as we know. But second, because they are also excluded by the way in which digital technology is designed and how government uses technology to actually categorize them and also to very often profile them. Secondly, we also see that technology is privatizing our democracies and public values. And also, it's becoming very difficult to set limits for this. It is important to think beyond the legal limits that competition law is setting now to big tech platforms, and also to think how privatization of public values is actually shifting our current perception of public law. Because citizens right now are being reduced to data categories. And when we reduce individuals to that, we also lose respect for their dignity. In that sense, two points that I want to bring in is basically that big tech can both be something that helps citizens or deepens inequalities. And the future of technology and public law depends very much on how we actually approach this topic and keep studying it just beyond the realm of equal treatment. Thank you.
Thank you, Sofia. Thank you very much for highlighting the double-edged sword, and the double-edged nature of technology, because I think, and this is something that we should consider not only, of course, in public law, but I think it's in life. Think of people going into a museum and in front of a painting of a Picasso. Now you see how many people don't see the Picasso through their eyes, but only through the device or the smartphone in order to take the picture. So, but on the other hand, thanks to this, that Picasso is flying over the world in order to be seen. So you see the double-edged sword of technology in many cases in our ordinary life. And thanks also to highlighting something that emerged also in Catalina and Jamal first intervention, that is the ambiguity of governmental power in the case of social platform, or how this kind of public power is exercised or not. Because it reminds me the very famous quote by Mark Zuckerberg, saying that Facebook in a lot of ways is much similar to a government than to a company. And this allowed me to now jump into the second part of our panel, that is a Q&A section between us. I asked the audience if they have questions for our final part to write them in the. We have already two in the specific section of Zoom on the Q&A. And I will dedicate the first part of this Q&A section to the topic of Facebook and Twitter versus Donald Trump. Now, I will kindly ask Catalina to describe briefly the facts that led to Donald Trump's social media account suspensions. And then I will ask Jamal to briefly describe neutrally what did the Facebook Oversight Board decide. And then we will leave Sofia attacking or defending what happened, but so that she will be freer since she's not part of the Oversight Board. So Catalina, the floor is yours if you want. I think that people, probably many people are waiting, because I also see a question already. We're waiting for this, so please go ahead.
Yeah, thank you, Lorenzo. The facts on the Trump case are relatively straightforward. On January 6, 2021, during the counting of the 2020 electoral votes, a mob forcibly entered the Capitol building in Washington, D.C. And this violence threatened the election. After all, 5 people died and many were injured. During these events, then President Donald Trump posted 2 pieces of content. As the riot continued at 4:12 21 Eastern Time, the former President Trump posted a video on Facebook and Instagram saying the following, and I quote, "I know your pain. I know you are hurt. We had an election that was stolen from us. It was a landslide election and everyone knows it, especially the other side. But you have to go home. Now, we have to have peace. We have to have law and order. We have to respect our great people in law and order. We won't want anybody hurt. It's a very tough period of time. There's never been a time like this where such a thing happened, where they could take away from all of us, from me, from you, from our country. This was a fraudulent election, but we can't play into the hands of these people. We have to have peace. So go home. We love you. You are very special. You have seen what happens. You see the way others are treated that are so bad and so evil. I know how you feel, but go home and go home in peace." An hour later, Facebook removed this post for violating its community standard on dangerous individuals and organizations. Then, as police were securing the Capitol, Mr. Trump posted a written statement on Facebook, and I quote, "These are things and events that happened when a sacred landslide election victory is so unceremoniously, viciously stripped away from great patriots who have been badly, unfairly treated for so long. Go home with love in peace. Remember this day forever." Facebook removed this second post for violating its community standard on dangerous individuals and organizations. It also blocked Mr. Trump from posting on Facebook or Instagram for 24 hours. That was the first decision. On January 7, after further reviewing Mr. Trump's post and recent communications of other public agencies, and more information about the violence at the Capitol, Facebook extended the block indefinitely and for at least the next 2 weeks until the peaceful transition of power is complete. And I end quote. On January 20, with the inauguration of President Joe Biden, Mr. Trump ceased to be the president of the United States. And on January 21, Facebook announced that it has referred this case to the board. So Jamal, would you be so kind to explain our decision so Sofia can say what she thinks about it?
Yeah.
Thank you. Go ahead, Lorenzo.
No, please go ahead, Jamal. I mean, Sofia will tell us who got it right. So no, I'm joking. So please go ahead, Jamal. Thank you very much.
Sure. And thank you, Catalina, for that excellent summary. There are basically 3 elements to the board's decision in the Trump case. The first is the determination that Facebook was justified in its initial decision to suspend Trump's access to his account. The company made that decision on the basis of its policy prohibiting praise of dangerous individuals and organizations. The people who forced their way into the Capitol on January 6th were rather obviously dangerous, and his praise for them was unambiguous. So the board examined the facts. It examined the overall context, including statements that President Trump made leading up to the events of January 6th, including both that morning and in the weeks leading up to the certification vote, and determined that Facebook was justified in finding his presence on the platform harmful under that dangerous individuals and organizations standard. The second element of the decision was a determination that Facebook's decision to suspend Trump's account access indefinitely was not a permissible posture and sanction for Facebook to impose on the account. An indefinite suspension was not one of the options available prior to the Trump case. Suspensions had to either be for a specific period of time or they had to be permanent. So a permanent suspension, at least that was the menu of options that Facebook had available. And so the board said, you've got to put in place a sanction that is in fact an available sanction and have to make relevant factual determinations necessary to justify whatever particular suspension the company decides to put in place. Determining account level suspensions or account level action for users was and remains Facebook's job, not the job of the Oversight Board, which is essentially, I'll use the court analogy, an appellate body. Whatever action the company reaches has to be bounded by some consistent and transparent framework. And I'll just mention that in 1 month after the decision, in response to the Oversight Board's decision, Facebook put in place a suspension of 2 years. The final element of the decision is a set of policy recommendations, and there were quite a number of them, so I won't go into great detail, but the board's recommendations related mostly to transparency around Facebook's system of account level enforcement, which was not very clear, and about Facebook's newsworthiness exception. They have an exception for newsworthiness, and how that exception operates was not very transparent. So we recommended additional transparency around it. And the board also issued recommendations about how Facebook responds to emergencies, how it interacts with law enforcement in situations of where there's harmful content on the platform, and how it assesses its own role in disseminating harmful content. So I'll stop there and I'll let Sofia praise or lay into the decision as she wishes.
Yeah, thank you, no, Sofia. So
thank you. What a responsibility. I must say, I will, like spoiler alerts, I actually am on the side of the Facebook Oversight Board of this, because I mean, we have to also look at the nature of Facebook, and I know, and we're going to delve into like the nature of Facebook in probably the Q&A, but I mean, but Facebook is at the end of the day still a platform that that maintains community guidelines, that has a responsibility not only for the preservation of its values, but also to make sure that it is not the one also disseminating messages of hate and terrorism. So in that sense, there is an added responsibility here. And I must say that here it's not only about, of course, community guidelines, not only about consumer protection, right? Because that it was in the beginning when we started looking at these platforms like eBay, for example, they have always had this kind of function of being a courthouse. But now we are seeing that it's more than that. There is even an appellate level, which is also important to make sure that the rule of law is respected. Also because we know that very often these decisions on who speaks and who doesn't are not always, performed by lawyers. They are most of the time, I believe, it's just artificial intelligence, performing this, this function. So I think having this appellate level is definitely very important. And I think the Facebook Oversight Board here played a very important role in making sure that the key legal values of our democracy also sustained. And these are also values that are, important not only in the United States where this, occurred, but also just in general. So it just conveyed a message that, Facebook is a guardian of speech, but also like of order. And in this context, we're just not talking about speech, but also hate speech. So in that sense, I do agree with the decision that was taken by the board, especially I think the key, there are 3 key points that I find very important to highlight, and Jamal also mentioned them, of course, the fact that sanctions, so the enforcement cannot be open-ended. So it is important to know exactly what kind of sanctions can be imposed a priori, and that they also consistent with them. So the policy has to remain consistent when it comes to enforcement. And that was an important point that was made, and it was also kept in a sense. Proportionality, I think, is also very important here to take into account. And proportionality also plays a role because we, of course, have to weigh in different values. And that was also something the Facebook Oversight Board did quite well in this case. And also, of course, in general, the ideas of transparency of rule of law in general were also very well, safeguarded. So I must say that, as I said at the beginning, I'm on the side of the board because I do think that the board played an essential role here. And I would say that freedom of speech is, of course, very important, but we're not talking just about regular speech. We're talking about hate speech, and also making sure that hate speech doesn't lead to acts of terrorism, as and that was basically the case in January this year.
Thank you, Sofia. I mean, I must say that I found, extremely interesting, and also somehow it was confirming what you were saying about the double-edged sword. Sorry if I got on that, but if we see what happened in the US case in 2008, in 2016, and in 2020, I mean, this is something that Barack Obama in his last book clearly describes. No, in 2008, there was the social platform where something new, and there was this enthusiasm, and there was a way to reach people, democracy. In 2016, we have the Cambridge Analytica scandal and all that happened. And in 2020, we had social platform at least try to address this issue, to the extent that we have the Oversight board with prominent lawyers and trying also to verify that the conduct and what happened was right and was lawful. So I think that only this sequence of facts, of events, gives the idea of the evolution of how public law and law in general try to address these issues. And this is why I will now go to Catalina, that in order to deepen what you were saying at the beginning about the idea of designing a fundamental right to the internet on the one hand. So can we design a fundamental right to the internet on the one hand, and on the other hand, because this is, I think that the pandemic made us thinking more and more about this. Can we design a right not to be reached by technology? So a right to not be reached by technology. So thanks to the floor is yours.
Thank you, Lorenzo. So 2 questions, yes. Let me answer you by remember what some countries have decided, no, about the right to access to the internet. This question can be understood in 2 ways. In the first place, as the right to access to the internet infrastructure, no, that is the positive obligation of the state to provide the required infrastructure for the internet access. In some countries, as Greece, for example, the obligation of the state to facilitate access to internet was recognized through constitutional amendments. In other countries, such as Argentina, this right is recognized by law. And finally, in other countries, which I think this is very interesting, the Supreme Courts or the constitutional courts are the one who recognize the right to access internet in this first sense as a positive obligation of the state. And this is a very important decision from the Supreme Court of Justice of Costa Rica in the Esquivel case in 2014. In that decision, the court ordered the state to carry out a project to assess the possibility of installing the necessary infrastructure to provide internet and cell phone services to a rural community that did not have that service. I think it's a landmark case. But you can understand this question no longer as a question about the positive obligation of the state to provide internet services, but rather a question about the negative obligation of the state to refrain from preventing people in certain circumstances to access internet services. I would like to take to mention at least 2 very important court judicial decisions on this matter. One from La India, from the Supreme Court of La India, in the Kashmir restriction petition. In this case, the Supreme Court declared that access to internet, in this sense, it's a fundamental right, and it was a case, as I said, concerning internet blocking. similarly, the Community Court of Justice of the Economic Community of West African States, in a case against Togo, Amnesty International against Togo, the court decided that access to the internet is a derivative right, as it enhange, no, you say enhange, I think I'm pronouncing, I don't know, well, enhance the exercise of freedom of expression. As such, the court ruled that internet access is a right that requires protection of the law, and any interference with it must be provided for by the law, specifying the grounds for such interference. So I share those decisions. Any restriction to the access to internet must be studied under the most strict scrutiny of proportionality. And then your second question, just very briefly to address this question, I think the case Big Brother Watch and others versus the United Kingdom provided plenty of clarity on the matter. In this case, the Grand Chamber from the European Tribunal of Human Rights found that the UK's regime on bulk interception and was, violating the human rights treaty. Well, I think, I would like you to refer to that case because it's a long case and it has a lot of material to work with. But just allow me to say this. For the court, the violation occurred given that, among other reasons, important deficiencies were detected in the surveillance programs. These deficiencies are, among others, the absence of independent authorization and oversight, so the so-called end-to-end safeguards. No categories of selectors were included in the applications for a warrant, and there was no prior internal approval of the selectors linked to an identifiable individual. And finally, the court says that the state did not examine other less intrusive measures before activating and implementing electronic surveillance programs, among other safeguards. So I think this case is very rich on this topic.
Thanks, Catalina. Sofia, you want to add something on this topic, on this question? So the fundamental right to internet and the so-called right to disconnect.
Yes, I would like to. I fully agree with the answer that Catalina gave, and I do think that there's quite a lot to be learned from the case law from Latin America. And I think we here in Europe, you very often do not take that into account. But judicial activism in Latin America is really worth taking a look at. And I would like to add something from a more European perspective, both on the fundamental rights to the internet and the right to disconnect. So one of the issues that I think the European Court of Human Rights needs to take more into account is the content of this fundamental right or human right to the internet. Because right now, as Catalina mentioned, it's mostly right to have access to infrastructure, the right to not be disconnected because of political reasons. But the thing is, as we are increasingly required to be connected, it is also important to see that the fundamental right to internet is not only just the right to be connected, it's not only just the right of access, but it has to be also the right to be educated, to have digital skills. So you should think of it not only from the first degree of digital divide, but actually we should look at different degrees of digital divide. And the European Court of Human Rights is not looking at it yet. So for example, in a recent decision from the European Court of Human Rights from February this year, the decision Stichting Lambert, actually the court said that in a country as well connected as the Netherlands, everyone should be assumed to actually have access to the internet and be able to use it. So in many cases, governments do not need to have a parallel offline services. They can just use online notifications for everything. And then I think is very problematic, because just saying that just because a country has great internet infrastructure does not mean that all citizens can have fully access to it and use it adequately. So I think this different dimension of the fundamental right to internet needs to be further explored. It's not only just having access to it, it's being able to use it correctly. And now regarding the right to disconnect, This is something that has been actually discussed mainly in labor law. So I think it is important to talk about the two dimensions, labor law dimension and the fundamental rights dimension. In labor law, of course, we have quite a lot of case law at European level on work time, of course. And we have a lot of legislation, either like already in place, for example, in France, or being discussed in other countries. And France, for example, has been a pioneer here, because even before there was new legislation in 2017, this right to disconnect was already actually discussed in case law, and an employer was actually fined by actually not giving the right to disconnect to an employee. So I think it is important to actually follow this development in Europe, because this right to disconnect has become increasingly important during the pandemic. And there are quite a lot of new developments. Also, the European Parliament has discussed this right to disconnect as something that should be adopted as a fundamental right beyond working time legislation. And the last issue that I would like to, or last suggestion that I'd like to make, is that we move beyond, labor law, because we have actually to ask ourselves whether we shouldn't have a broader right to disconnect, in the sense that if all these institutions move online, if everything is digital by default, how about citizens that do not want to be online because of different concerns, because of autonomy concerns or privacy concerns? And I would say that these citizens perhaps should have a right to disconnect, as long as it is proportionate, as long as it does not impose too many burdens on public authorities. And so in that sense, I think the right to disconnect shouldn't be only tied in to the right to disconnect from work related chores, but also the right to disconnect in general from the digital world, if we actually have alternatives to actually make sure that the citizens can keep exercising their fundamental rights. So the exercise of fundamental rights should not depend on having a technological medium to actually be able to do so.
Thanks, Sofia. And then, you're right that even during the pandemic, we had in Europe this discussion about the possibility to impose people to register themselves for the app to give the data for being or not infected by COVID. No, so at the end, the decision was something that couldn't be mandatory. So and somehow this is a right not to be reached by technology, because you could choose not to have the app. I will now turn to Jamal. So democracies, we can say that, survive because of truth. And so fake news can be considered as the true enemy of democracy. And if so, how can we fight them? How can we fight fake news, according to you?
Well, listen carefully, because I'm going to give everyone the answer on how to fight fake news. So it's obviously a hard and complicated problem. I think I might just first resist the frame a little bit, insofar as of course, I think democracy is a very important value. It isn't obvious to me that democracy is necessarily the highest value for a private social media platform to serve, or even in some contexts for the government to serve, unless we understand democracy very broadly to include the vindication of certain human rights, the prevention of harm to people, and other kind of humanistic values that, to my mind, sometimes sit in tension with popular self-government, if that's how we understand democracy. Misinformation and its sinister cousin, disinformation, can be harmful. Of course, they can harm people. They can harm people physically. They can harm people financially. They can harm people emotionally, and so forth. They can undermine elections, as we've seen. The thing is, though, misinformation is not inherently harmful. It can prevent harm in some circumstances. And maybe most importantly, it's very easy to overdo the policing of misinformation. And so that's the kind of crux of the problem. Lying, and I'll just use the less euphemistic term, right? Lying has some value in its own right, insofar as it respects the autonomy of individuals to decide how to present themselves to the world, what information to put into the world. But much more important than those autonomy values to me is an epistemic problem that policing lies is hugely difficult, especially at scale, right? Truth is not always known. It is very often contested. There's a lot of nuance, right? Misinformation is not a binary, it's a spectrum. And I say that as someone who used to be a professional fact checker, that there are degrees and shades of truth and falsity. And policing it is also very resource intensive. It's hard, it takes a lot of time and effort. And so a very heavy hand on policing misinformation is going to end up removing some true expression from the world, and can be threatening to privacy and autonomy. And it can also engender mistrust, right? So given all of that, and I'm just trying to describe, without saying what the answer is, describe the complexity of the problem. I think it's going to be productive and is productive to get much more granular and try to focus on specific harms rather than treating the problem of misinformation as just a general abstract problem, because I think it's not an abstract problem. So focusing on disinformation, right? That's misinformation that's intentionally meant to deceive people as being a special problem. Focusing on coordination as being a special problem. Random fleeting lies are much less problematic than coordinated disinformation. Focusing on influential individuals and users more than on others. Trying to get creative and continue to be creative in terms of how you remedy misinformation, downranking, engaging in forms of counter speech, other measures that increase the friction for lies to be disseminated and to affect things at scale. So I think it's hard to speak about the problem in the abstract because it's complicated and it's very easy to over enforce. But to try to be more specific about when we think it's especially harmful and when we think we can tolerate misinformation because of other values that we think are important.
Thanks, Jamal. No, it's true that at the end, fake news are enemy of democracy since ancient Greece. No, so technology has, of course, enhanced the risk of having this fake news disseminated with misinformation. But on the other hand, and this goes back with the ambiguities of technology, or the what Sofia called the double-edged sword. We had also instrument like intelligence for moderation of contents, algorithms, in order to try to fight against this dissemination of misinformation. So this is something that we should work on with all the risks that we are aware of. So this brings to a point that I will ask Catalina, that probably she already mentioned in her first response. So should social media be regulated at the global level?
Yes, I think social media must be regulated at the global level because social media is global. So if you have national regulations, then you broke the architecture of internet, and you need to respect that. If you would like to maintain the democratizing potential of internet, then you need to respect internet as a global, open, interconnected, and very interactive like network. So you need global norms to do that. The problem is that I think we are not in the best international context to create a new global regulation for internet. We have big actors now playing, which are not very commitment with human rights. So maybe we need to wait a little bit until we have a better context to regulate globally human rights. But we have regional experiences, regional intents. For example, in Europe, they are trying to have a good, I think it's a good, it's a promising regional regulation. The problem is that while the whole European community is trying to reach that European regulation, some countries, as Poland, for example, decided to create their own regulation, national regulation, not very well aligned with human rights. So the short answer, Lorenzo, is yes.
Thank you, Catalina. And now I will ask Jamal, sort of rhetorical question probably, but I think it's important to highlight this problem that is, is freedom of expression at risk in the Google era, because also all the issues that we tried to raise in this first hour. What do you think?
So I think if I want to be provocative, I could say no. It's not. I think that's not a complete answer, but there is something, I think, to that answer, insofar as I find myself much more worried about too much freedom of expression than too little. Now, there are ways of characterizing that problem as itself a problem of freedom of expression, insofar as shooting information at someone through a fire hose can stifle their own expression, right? There are ways of describing it from both angles. And when I say I worry about too much expression, I don't say that to minimize the problem of censorship, which is a very active, live, important problem. And it's of course the case that many governments around the world censor speech, attack their political enemies on the basis of their expression and their political opinions. But it is to say that that's not a new problem, right? That's an old problem. It's an old problem that there are ways in which the rise of certain technological mediums and the concentration of expression on particular mediums does give some leverage to those who want to suppress expression. And Sofia alluded to this somewhat in her presentation. But I think what's genuinely new is the rise of private governors and the migration of the public square to online spaces. It seems, I'll even say obvious to me, that on balance, it remains the case that free expression has been and continues to be greatly enhanced over the status quo by digital technology and the rise of social media. There are many more outlets than there once were. There are many fewer intermediaries than there once were. That gives rise to other problems, right? And there are lots of problems associated with big tech and with standards for content moderation, with privacy in particular, with those who actually don't want to participate in that public square in the form in which it presents itself. But if we are speaking solely in terms of freedom of expression and understanding it in relatively narrow terms, I think that I think that it's been enhanced rather than stifled in this era, which again doesn't mean that there aren't other problems associated with it.
Yeah. Oh, thanks, Jamal. I mean, a discussion that we have in Europe and probably in other countries is then to what extent freedom of expression can be protected once you use social network in an anonymous way, you know? So this brings to the fact of being identified or registering yourself in a way that so you are yourself, as you know. But then people say that freedom of expression is also to use a fake name in order to be free to be on the social platform. So that's why that's a tricky point. Sofia, a last question for you before we open the Q&A from the audience. So we already seen this discussion that technology somehow is changing the very concept of state, and if so, it's assuming that could be, in what way or ways you think that the very concept of state is affected by technology?
I think here you are also alluding to to the quotes of Mark Zuckerberg and the fact that there has been some scholarship that actually argues that big tech platforms, but especially, of course, Facebook, because it owns like 3 of the biggest communication vehicles right now on the market, may actually be performing state-like functions. And I understand the metaphor, and this is something that I have discussed at conferences as well. And I think this metaphor might be partially right, partially incorrect, because it is true that Facebook has quite a lot of power, which can resemble in many ways, what states do. It has legislative power, executive power, judicial power. But at the same time, when we think of it, I mean, it is then like, correct to draw the comparison to, to older companies, for example, the East Indies company that also had similar functions, even more. They even had an army. They had a currency. So in that sense, you could actually think that, you can compare it to existing companies. But actually, the more I think of it, the more I actually realize that maybe it's not really just, like the Facebook and all this stuff that are changing the states or are trying to appropriate the state, but it's mostly that we should think about other ways of understanding this phenomenon through the eyes of global regulation. Just exactly, so I fully support Catalina's proposition here, because it's not exactly that they are overtaking the state. It's just that, as the question suggests, the state is changing. The functions of our states are changing, and part of it has to do with the globalization. The fact that many of what once was national has now become global, like speech, for example. But also it has to do with the fact that privatization has taken different forms. We are not just privatizing railways nowadays. We are privatizing information, privatizing the oversight of information. So in that sense, I would say that perhaps big tech is changing a little bit the states, or greatly the state, depending on what areas we're focusing on. But mostly it is changing the way in which we perceive certain traditional tasks, especially speech and information. And what we see is that nowadays we are delegating certain tasks to private actors. And the question, of course, is whether this is rightful or not. But it is important to see this as a natural evolution of our world. I mean, globalization is needed, so it's not necessarily bad, but it just means that the state has to give up certain tasks, and new checks and balances have to be created, and they have to be created at global level. And this basically, as it has been discussed by a number of very established scholars in the field of global administrative law, we have to actually create mechanisms for these networks to operate at global, national level, and local level. And this is basically what still doesn't really work very well. So we need to establish that we already have many examples of global administrative law that works, or that at least works better than in the internet. And then I think we should draw more inspiration from that. So I wouldn't say it's not a platform that is usurping, state power. It's more, as you said, that states are changing and are moving some of their national tasks to the global arena.
Thanks, Sofia. Yeah, I mean, I do think that you're right, is that technology is probably, creating a crisis in the idea of democratic state. But if we consider the very concept of state, because we have also states which not are completely democratic, I mean, we are aware of that. So in that case, technology could be even an instrument for strengthening the state and not for weakening it. So and now we have almost 20 minutes for the Q&A section from the audience. We have 7. I think that we already had a response on one of them. So I will immediately ask to Catalina from Mariana. I mean, in your basically supporting a global regulation of social media, I mean, I will ask you directly, because I think this is very interesting. So who would effectively enforce those global rules according to you? So how do you imagine that we can implement or those and effectively enforce those rules?
Okay, thank you. Thank you, Lorenzo, and thank you, Mariana. One of the things that I appreciate the most about ICON is its attempt to include different languages and cultures. So I would switch to Spanish because we have Adriana.
Okay.
and she will help us in the interpretation to English. So, yo creo que la única manera de regular adecuadamente una red global, nuevamente lo repito, es a través de normas globales. Eso significaría tener instituciones globales capaces de hacer cumplir esa regulación. Pero claro, ahí hay problemas serios de enforcement. Y entonces tendría que existir un foro multisectorial en el que las propias compañías se comprometan a cumplir de la misma manera como los estados se comprometen a cumplir el derecho internacional de los derechos humanos. Por supuesto, hay enormes desafíos como lo estamos viendo en este momento con el declive que hay en la democracia a nivel global de estados que han decidido incumplir sus propios compromisos en materia de derechos humanos. Pasaría lo mismo eventualmente con las plataformas, pero creo que es la mejor manera para mantener, como ya lo mencionó y como Sofía también lo señaló, el potencial democratizador de Internet, es decir, el mejor lado de la moneda de Internet.
Thank you, Catalina. I mean, I agree with you, and basically that is probably the most challenging issue that we have to face in the next years. Jamal, someone asked about something more about the decision of the Oversight Board, but I mean, I think that this question probably is something that you can try to address. So one question is the recommendations that were given are applicable across jurisdictions, and the other question is, I mean, what happens if Facebook simply decide to ignore those recommendations? So
sure. So as to the first question, yes, the recommendations and all of Facebook's policies, as far as I can tell, are applicable across jurisdictions. Facebook operates, although it's a US company, it operates in many jurisdictions around the world. And part of the challenge, and this relates to what Catalina just mentioned, right? Part of the challenge of both Facebook's own internal regulation and the board's oversight of Facebook is to try to develop norms and rules that really can apply across a number of different jurisdictions. So that's part of the charge of the board, and one that the board takes quite seriously. Now, as to Facebook ignoring recommendations, I'll say a couple of things. So one is that Facebook has committed itself to not ignoring those recommendations. So it has to, just as the recommendations themselves are publicly available, Facebook is obligated by contract to publicly respond to the recommendation. So ignoring them entirely is an option that Facebook has itself taken off the table. Now, that said, of course, Facebook could decide not to comply with a recommendation. It could say, we disagree with this recommendation, or we think it's not feasible, or something along those lines. And there, because that response is public, both the board and the many people around the world who are close watchers of what Facebook does can respond to that. They can agree with Facebook or disagree with Facebook. They can criticize Facebook, and that is promoting of dialogue around the different policy options that Facebook engages in. This is how it's supposed to work. And I'll say, and that if Facebook is agreeing with everything the board is saying, then that might be an indication that the board is not being sufficiently ambitious in challenging Facebook's practices, right? So some kind of dialogue and back and forth about the board saying, why don't you, we really think you should do this, Facebook telling the board, here's why we can or can't do that, is an important part of the dialogue the board was set up to engage in.
Thank you, Jamal. And Sofia, I mean, Irene raised a crucial question related to the role of online platforms and the public and private divide and distinction. So she asked, how can we guarantee that online platforms moderate content in a human rights compatible way? so respecting the right of freedom of expression. So how do you deal with this?
Well, this raises, of course, a big question, also the question that has also been discussed in other contexts, in the multinational contexts, for example, on the horizontal character of human rights. So in that sense, you of course we have that legacy we could rely upon. But I would say that contrary to the traditional problems we had with with multinationals, or even before even that, in the beginning of the 20th century, with violations of human rights, for example, by certain companies in Congo or in Latin South America, I think nowadays we have companies that have a little bit more of a perception of what human rights are, fundamental rights are. That's a big distinction that I think people very often forget. So in essence, the legal framework has shifted. There is more awareness. But I do think that if we are to actually make sure that all platforms, especially the ones that do not have the same values as we in the West share, if we are to make sure that they also are aligned with, I think it is important to have global regulation again. So in that sense, I mean, I refer again to Catalina's answer, because that is the only way to make sure that these platforms abide by the same rules. Otherwise, we don't have any guarantees. So even if we refer to the legacy of horizontal character of human rights, we know how that works in practice. We also know that there are some success stories involving multinationals, but there are also a lot of failures. So in that sense, I think having enforceable global regulations is probably the only way to make sure that all the platforms play by the same rules. Otherwise, we may have good platforms that actually do have a system in place, but we also have other platforms that might actually not be willing to actually do that, or might actually succumb to national rules and national powers.
Thanks, Sofia. I mean, we have two final questions. I mean, one, I guess that probably we already offers sort of response, because Felicia Caponegri was asking what is what do you think as panelists of the Facebook Oversight Board from the international and comparative legal perspective? And so I think that is something that we discuss. But Argelia say something interesting, and I would like to know from you. I will start from Jamal. She writes that the new Charter of Digital Rights in Spain has introduced the right to remain analogical. So basically, that's a sort of escape from the digital revolution. So how do you see this?
So I think that seems to me in the abstract to be a very sensible right to provide to people, and I think it's in the spirit of kind of third wave human rights, so cultural rights as well, of having a right to not participate in certain currents of modernization is, I think, quite important. I think how to realize that right and what to do when it conflicts with other rights, including the right to access certain kinds of services, as was mentioned earlier. I think you, Lorenzo, mentioned it in the context of the pandemic. There are ways in which digitization can be helpful in the context of public health and other forms of public regulation. I think the conflict between those rights, I think, gets worked out in the way we ordinarily work out conflicts of human rights in terms of proportionality. And I think that over time it will be increasingly difficult to maintain that right to remain analogical in ways that are untouched by other kinds of regulation. But in the abstract, it seems to me quite sensible and quite in line with other kinds of rights that we expect states to respect and promote.
Thanks. And I mean, Sofia, I mean, do you agree? I mean, what do you think also what Argelia wrote us?
I mean, I think, as I mentioned before, I think this is in line with the right to disconnect and what we already discussed before. And I also agree with Jamal that for now, I think it is feasible. But the question, of course, is like, well, how we were going to move forward. So this is, I think, that for the coming, decade of something, I think we can definitely maintain this right to remain analogical, and probably we could maintain it further. But of course, the question is whether this will be proportionate in a few years from now, in a few decades from now, and how we actually will address it. But I think for now, it is totally in line with also the dangers that we also see from privacy and security perspective, and autonomy, of course, of the individual.
Thank you, Sofia. So I will have a very final question to Jamal and to Catalina without embarrassing them, because I mean we received also other questions on the oversight course. So the question is the following: according to the experience that you had, you think that this is a model that can be applied in other contexts? So it's something that we can export, or do you believe that is something so peculiar that can work for Facebook and you don't see? So I think that this is something that you can respond, without compromising yourself. So according to what experience? So I don't know who wants to start first, if Jamal or Catalina.
I can start if I think if we understand the oversight board at a relatively high level of generality, then yes, I do think there is some promise in it. We still have to wait and see exactly how successful the oversight board is at its own function. But the general problem of trying to regulate freedom of expression when the existing institutions are motivated by agendas that render them not very trustworthy. So on the one hand, private actors who have financial and reputational interests, and on the other hand, governments who have political or partisan interests. So what's in between that? Well, we don't know. What's in between that is some institution that has indicia of trust, and that sometimes, in some contexts, that results from electoral accountability, which the oversight board, of course, does not have. But sometimes that results from expertise, which the oversight board does have. Sometimes that results from reflecting on the quality of the work product. And I think that that's probably most promising, is that over time, if the oversight board does a good job at its task, then it becomes a more trusted institution. Facebook is a very particular context. The oversight board is very expensive. Not every institution, not every social media platform is going to very easily be able to avail itself of that kind of solution. I'm not so self-confident, right, to say that the oversight board in precisely its form can work in every context. But the general model of institutions staffed by people who are accountable to their work product and develop and engender trust over time as an alternative to the poles of government and private and purely financially motivated regulation, I think is promising, and in fact, maybe the only possible solution.
Thank you, Jamal. Catalina, you want to add something to?
Yes, thank you, Lorenzo. Now I will switch to Spanish, no? I will speak Spanish. Yo creo que un modelo de autorregulación con órganos que tengan garantías institucionales, presupuestales, funcionales para operar de manera autónoma e independiente es un buen modelo. Pero creo que es un modelo insuficiente. Por eso creo en la importancia de regulaciones globales. Sin embargo, como me parece que hoy pensar en regulaciones globales puede ser difícil, puede ser incluso peligroso, vuelvo a aquello con lo que empecé. Quienes hoy están llamados a decidir eso sobre moderación de contenidos en muchos países del mundo son los jueces. Y por eso es tan importante que los jueces puedan aplicar el derecho internacional de los derechos humanos a sus propias jurisdicciones. Y por eso es tan importante reconocer esos mecanismos de derecho constitucional comparado, como por ejemplo la doctrina del bloque de constitucionalidad en América Latina. La idea del bloque de constitucionalidad del Consejo Constitucional francés ha sido desarrollada en América Latina de forma muy creativa para incorporar al régimen constitucional el derecho internacional de los derechos humanos. Y los jueces lo han aplicado a las relaciones entre particulares de manera directa. Y lo han hecho a través de un diálogo con todos los actores interesados, que es lo que hemos denominado el constitucionalismo dialógico. Entonces, claro, el modelo de la autorregulación es bueno. Como dice Jamal, probablemente las otras compañías no tendrán la potencia de Facebook para crear un órgano tan costoso, pero existen otros modelos de autorregulación que pueden crear y para nosotros sería extraordinario poder conversar con otros órganos de autorregulación. Pero tenemos que apostarle a una regulación global y mientras tanto necesitamos que los jueces desarrollen mecanismos que les permitan tomar decisiones adecuadas. Y para eso, esas experiencias del derecho comparado yo creo que son muy valiosas.
Thanks, Catalina, and I think really also thanks on behalf of ICONS, because basically you are saying that we need comparative law, multidisciplinarity, and merging and having an approach that could put together, as we tried today, international law, constitutional law, administrative law. We need all the branches of public law in order to address this phenomenon, and this is something that I think that technology makes quite clear. I mean, that we need all these different perspectives. This is what we try to do in our plenary events. Before we say goodbye to everyone, I had to say a big thanks to our main sponsor, the city of Wrocław, the Konrad Adenauer Stiftung, Ran Hirsch, and the NYU Law. Because of them, we were able to set this conference this year. So I thank again the panelists, Jamal, Sofia, and Catalina, for really giving us a wonderful 90 minutes of discussion about the future of public law in connection with technology. Thanks to all of you. Thanks for the audience, and I look forward to seeing you in the panels of our conference in the next days. Thanks.
Thank you, Lorenzo.